Call the Rules Subcommittee on Impeachment to order, and Councilman Lay will give the blessing.
Lord, we thank you for the time to gather up together today and do the people's business, and we hope we do it in a manner that you would want us to. We feel blessed today to be here, and in God's name we pray. Amen.
Call the roll.
Chuck Hoskin Jr.,
Here.
Jody Fishinghop, Tana Glory Jordan,
Present.
Lee Keener,
Holly.
Dick Lowe,
Here.
Curtis Snell, David Thornton,
Here.
David Walkingstick. We do have a quorum.
Thank you. Next, just some prefatory remarks. The sole purpose of this subcommittee is to consider legislation to amend the existing impeachment act. That I've run across some confusion in the community about what the purpose of this is, and the sole purpose is to consider that legislation. Legislation was introduced in the Rules Committee some months ago. One of the sponsors is on this subcommittee, Councilman Keener, and I wonder, Councilman Keener, if you would move for the approval of your legislation so you can get us into debate.
So moved.
Second.
All right, thank you, Councilman. I have had Shelley pass out to the committee members and shared a copy with Mr. Hembry some amendments to Councilman Keener's legislation. And I know, Councilman, you haven't had a chance to probably look at any of these because they were just presented to you, but just to bring them to your attention, not in your packet, but loose, you'll find, yes?
Are there anything different on what you handed out than what's in the book?
There is,
Okay.
Councilman. What's in the book is reproduced in this copy, this loose copy, but I have some red line changes. And those changes begin at page 3. To get us into debate on those amendments, I'd entertain a motion to amend. Yes, Councilman.
Maybe I'm wrong, but I'd like to start out with the beginning in the section 3 legislative history, and there's been changes in that, and just go through your copy and
Okay.
go. I don't think we're going to be able to do this all today. It's just the way I feel about it. I don't know. I think we need to look over this and look over it good.
I don't think that's a bad idea, Councilman. Maybe, Mr. Keener, maybe you could take us through the amendments that are reflected in your proposal.
Okay.
And then as we get to the sections where I've amended them, maybe we can just discuss it in that manner. So,
Okay, yes,
go ahead, Councilman.
that would be my preference too on this. And I guess if you don't mind, I'll start with section 1 because there is a change on that as well, although minor, but just so we have covered it. So that would please the chair. Yeah. Section 1, title and codification. This legislative act shall be titled as the Impeachment Procedures for Elected and Appointed Officials Act of 2011 and codified, and then the word as is stricken under Title 51, Chapter 8, Section 81 of the Cherokee Nation Code, annotated. And I had a question mark on the first section there, Todd. Do we need to research that anymore on codification?
Yeah, we need to, when we plug in that correct section number, and I can, just give me a few moments and I can find that.
Okay, thank you. Any questions on section 1 before we proceed?
Yeah.
Yes, Councilman.
Appointed officials, and I'll direct this question to Mr. Keener, would include Secretary of State, Attorney General, and Marshal.
Well, I think it is open for interpretation right now, since I think we're trying to make that determination to include that. So I'm not going to say yes if we want to discuss that.
Are there others that you can think of that might be appointed officials that we might want to include?
Well, I think certainly there could be, because there were a lot of appointments, but do we want to be specific on this, or?
I would like to see a definition of an appointed official and I would defer to Mr. Thornton.
I would like to see maybe think about the Secretary of State being under this also. Because that position is appointed by the chief, and I think it's approved by this body, right?
And there is a section, Mr. Keener, under section 4, where you deal with definitions, where you define officials, and you've expanded that. I don't mean to jump ahead, but you've expanded that a bit, and I wonder if we could, when we get to that point, we might discuss including Secretary of State, perhaps Treasurer.
Okay, it's just, I wanted to make sure that we all knew that this is for discussion, and I didn't want to say yes or no to the question. Thank you. So section 2, the purpose of this act is to establish procedures for impeachment of the principal chief, the deputy principal chief, or tribal council members, the attorney general, and marshal, hereinafter elected as stricken, hereinafter officials. So, and that, as you pointed out, that could be part of section 4, or we could add Secretary of State right there. I guess we want to discuss that one, or do you want to discuss that now since we're?
That's fine. If one of the members needs to make a motion to amend this section, that would be
I'd
fine.
make a motion to amend the section and add Secretary of State.
Yeah, I would second that.
Second, Councilman Lane.
I have a question about the definitions, like Tina was asking about, of who is an appointed official. Well, we sure got a lot of appointments. Councilor Thornton's already mentioned that. Does an appointed official discuss the treasurer, the secretary of state, the chief marshal, all of the folks we're getting ready to send to CMB, tax commission? I mean, we're getting ready to, I think, pretty quickly here, vote on appointments for a lot of appointed officials. Are these already taken care of under some other method, or?
Maybe Todd could speak to that. Todd, can you weigh in on this idea of including other appointed officials under this act?
The reason that the states, it is limited right now to Attorney General Marshall, is that the genesis of this act was to bring this up to date from our previous constitution to our current constitution. Now, so in our current constitution, in the 99 Constitution, and it says right here in section 3, it says the principal chief, deputy principal chief, members of the council, attorney general, and marshal shall be subject to removal from office for willful neglect of duty. And so those are the officials that can be removed pursuant to Article 9, Section 1. Now, as to other officials, you could incorporate those. You would need to, whether you wanted to add the Secretary of State. Now, there are other officials, such as, well, for instance, administrative law judges. There's a provision on their removal, I believe, in the Administrative Procedures Act. Gaming Commission, whether those people can be removed under the Gaming Commission Act, I'll have to look at that. So, and also, obviously, as to corporation board members, they can be removed by this council through the Appointment Act. Okay, so they can, we can expand it, but I would have to research the other laws to make sure that we were consecutive with them.
Since we're talking about this, Todd, how about the treasurer?
Treasurer, you could add the treasurer on there. It is an appointed official.
And that's a really important position.
Yes, it is.
I'm not saying that they're going to do anything wrong, but I'm saying when you're likely to handling $1 billion, well, I think you fall under this type of an appointment. And that's just what I think. I don't think that our treasurer will do anything of that nature, but who knows?
Well, and it is important to use your words to watch the watcher, okay?
There you go.
Yeah, it's important.
You got that, didn't
Yeah, I got that, I got that. And the important thing is on positions of, and I don't want to say great importance, but of great governmental importance, such as Secretary of State, Treasurer. Obviously, those would be some that you may want to incorporate in this act. Now, under the Constitution, you have to have the Marshal and Attorney General. You couldn't delete them. Now, if you can add other appointed officials and give them the same due process, that'd be fine, but I would limit it to just the higher echelon, such as Treasurer, Secretary of State, any other, with administrative board, just to say that anyone that you confirm can be brought under this act. We may want to limit that, but as to especially offices that are mentioned in the Constitution, that this would be appropriate to be under that purview.
Councilman Thornton has a motion to include Secretary of State.
And I'd like
Would
to
you
add
amend that
treasurer.
so he's amended it to do
And,
treasurer?
It isn't, like I said, it isn't because I think that our people are going to do anything, but I think that you need to think about over the years, not only in the Cherokee Nation, UKP, any other nation that's out there, there's corruption. And I think we need to get a handle on it and help our people keep a handle on it. And that's just the way I think about it. So that's the reason I like to add those.
Any objection from his second on that, amending his motion? So it would be Secretary of State and Treasurer rather than just Secretary of State as he first presented it.
I don't have any objection. I do have a question.
And I have a question. No, whenever you
Councilman.
So, as I take it from Todd, then we should limit these to the constitutional appointments, you feel?
That would be my recommendation, that, this is an impeachment act, there's, which is brought under the Article 9 of the Constitution. So I wouldn't be overly expansive in this, but I would, but right now that just says, the article itself says Chief, Deputy Chief, Counsel, Attorney General, Marshal. Okay, those are the 5 offices specifically listed in that act. Now, there are 2 other appointed offices in the Constitution that are now filled, and those are Secretary of State and Treasurer. Now, there are some other offices in the, well, I can think of one just off the top of my head, the Delegate of Congress that has never been filled is an appointed office through the Constitution. Now, whether we would want to go through the Constitution and say, everyone who's mentioned in the Constitution that is a constitutional office can be brought under the auspices of the Act, maybe. We can do a quick search of that Constitution. But it is not, I would be very specific in the limitations in the Act, and Treasurer and Secretary of State obviously are very important offices that wouldn't offend anyone's sensibilities to bring it under the Act.
Councilman Boyd.
Yes. Concerning those 2 positions, Todd, is there any other method by which we can remove them once they're appointed?
I can't think of one off the top of my head as to Secretary of State and Treasurer.
Do you recall during the Constitutional Convention, because I know you were a member and I was also a member, and I cannot recall if there was a discussion about those 2 appointed positions and why we would have not included those within that portion of the Constitution.
We can look at the record, obviously. I mean, it's the transcripts of the Constitutional Convention. I can't think, because I was sitting there thinking, why did we just limit it to those 2? I can't remember the discussion on that.
And I cannot recall that. Of course, that's been, what?
12 years ago.
12 years ago. I would ask consideration of tabling the idea of adding them till we have Todd look at the records to reflect if there was any conversation at the Constitutional Convention regarding those two positions. I just cannot believe that we failed to cover some idea of how to remove those individuals without, there was some reason, I'm sure, why we didn't put them in that portion of the Constitution. And I can certainly see if y'all want to move on ahead with that, but that's I want to be consistent with what they did during that convention as much as we can.
We've got a motion to table Councilman Thornton's amendment. Do we have a second?
Sounds like we want to vote on
Well, I'll second it.
We have a second. All those in favor of tabling to, Todd, can I ask you a technical question? Can we just table this to the next subcommittee meeting, or can we table it to the end of this discussion? I guess we're probably not going to find we're not going to have the research the councilwoman wants until probably next meeting anyway, so.
Well, yeah, I mean, I would have to look at the transcripts of that segment of the convention.
it.
Yes, Councilman Wood.
Yeah. And I want to go on record saying if there's not another method by which to remove the two of them for some misuse of their office, then I will certainly join Mr. Thornton in his motion.
Councilman Thornton?
I don't really see any problem with keeping them there right now, because we're not going to end this today. And I think things that we want Todd to check on and bring forward, I think that he can do that. I don't think he has to have a motion to do that. I think that this body says, Todd, we want you to check this out before we pass this and see if it's legal, or if they're covered by some other way of authority, or just see what's going on. I don't think we'd probably have to pass it.
And this is something that with the indulgence of the chair,
I think this should actually be, Council Lady, I think this should be an ongoing type of deal, and if we have questions, that we'd go to Todd. And if Todd can bring us an answer next month, this isn't going to go before the body this coming month, that I can see.
The motion is to
Correct.
table, and it's not debatable, but it probably is useful to keep moving and mindful that we can, in future months, take stuff back. I know it's not a debatable motion. You still have your motion on the floor, Councilman.
then Mr. Chairman, if I may indulge, subcommittees obviously are a less formal mechanism than a full, from a full committee. It's more akin to a working group, and I would say that Councilperson Thornton's right. I mean, there are going to be a number of issues that we are going to need to discuss and be ready for next month, and maybe the month after that. I don't know, but as to the one thing that we may do instead of go through a series of motions is just literally go through the document and identify those questions today, what needs to be further researched, and then come back and then actually taking votes on what we're going to add in and delete out at a subsequent meeting.
I
Councilman.
would like to withdraw my motion to table in a spirit of cooperation. I think we can join Mr. Thornton in adding those two individuals and letting Todd seek that information out through the Constitutional Convention.
So Todd, is it your recommendation that we go ahead and take a vote on Councilman Thornton's motion, or that we simply make a note that this is an issue we're studying?
I would like to make a note that it's an issue to, let's go through the whole document, see what issues are out there. Come back, we all do our research.
Okay.
I'll withdraw the motion.
Okay, very good. All right. Very good. Councilman Keener, the floor is yours again.
Thank you, Mr. Chair. Also, before we leave this subject, I would like also to consider a delegate to Congress be added. My thought here is that has been by treaty, but not yet honored. So if we, as a body, act as if it will be, hopefully someday that will come to fruition. And if we don't, we can certainly come back later and amend it, but it may be a preemptive part of this that we won't have to redress in the future when hopefully that happy day does come. Thank you. Okay, section 3, legislative history, and I'll just read the part that's not marked out, if that's acceptable to the body. Article 11, section 1 of the Cherokee Nation Constitution states, the principal chief, deputy principal chief, members of the council, attorney general, and marshal shall be subject to removal from office for willful neglect of duty, corruption in office, habitual drunkenness, incompetency, or any conviction of a felony or a crime under the laws of the Cherokee Nation that if committed in some other jurisdiction would be a felony or a misdemeanor involving moral turpitude or offenses against the Cherokee Nation committed while in office. I'm sure we're going to have some discussion on that.
Mr. Keenan, this is just taken straight from the Constitution.
Yes, is there any, we won't be able to change that, right?
Todd, this is part of the housekeeping of this legislation, correct?
Right, now there obviously are some terms in here that we may want to define under the definition portions.
Councilman Gordon?
I don't, does the Constitution have anything to do with the article that's been crossed out, been lined out? Is that in the Constitution?
What part?
Section 3, legislative history, the first section that's been crossed, section 1 that's been lined out.
Yes,
Is that the Constitution?
that's the 76 Constitution. That was what was currently in the Act.
Okay. Now, what is, in this second part, is this the
99 Constitution.
99 Constitution?
Correct.
And it includes misdemeanors involving,
Right.
and that's in the Constitution?
That's in the, that is direct constitutional language.
And the felony also?
Yes.
Yeah, I don't have a problem.
Councilman Keenan?
Thank you.
Constitution has it.
Well, then we move to, let's see, the second section there, Article 11, Section 2 of the Cherokee Nation Constitution states, except as otherwise provided in this Constitution, all other appointed officials shall be subject to removal for cause as prescribed by law. Article 11, Section 3 of the Cherokee Nation Constitution states, no official may be removed under Sections 1 or 2 of this article or Section 8 of Article 8, except after trial before the council, with the accused having been afforded due process and opportunity to be heard, provided removal from Sections 1 or 2 of this article or Section 8 of Article 8 shall require a 2/3 vote of the members of the council, which is also the 99 Constitution.
Does the section, one of the sections he just read, back on page 1, says, except as otherwise provided in this Constitution, all other appointed officials shall be subject to removal for cause as prescribed by law. I mean, that suggests that the delegates had something different in mind maybe for the other appointed officials. I don't know, I don't recall that, but.
Well, for instance, an appointed official under this Constitution would be members of the Election Commission. The Election Commission has a specific statute as to how you would remove an election commissioner. So that's an example of another appointed official. Now, maybe it was contemplated that we would have a Treasurer's Act, or that we would have a Secretary of State Act, which we don't have. Okay, but to satisfy this requirement, the Constitution says the other, that other appointed officials can be removed as prescribed by law. Well, you're in the process of prescribing law right now, and you could incorporate them if you so wished.
Very good, thank you.
Why,
Councilman Thornton?
why would we take out the test by the council? Is that just something that wasn't in there?
On which section? Oh, as to,
Section 2?
yes, I don't know. I can't tell you why those words were deleted, but I did notice that. It says, as may be provided by laws passed by the council under the 76 Constitution, under the 99, it just says, as prescribed by law.
Yeah.
Maybe it's a stylistic change, maybe they just thought it was, additional verbiage, I don't know.
Okay.
Councilman Keenan?
It would be common knowledge that it would be passed by the council anyway, so maybe that's the reason.
Okay, now we're on section 4, the definitions. And then A, special prosecutor means, and then of course, that's just a correction, an attorney admitted to practice law before the highest court of the state of which he or she is a resident and shall not be an employee, contractor, or official of the Cherokee Nation. Would you like me to read the entirety, Mr. Chair, or stop after each?
If someone has a question, that's fine. I don't see any questions on this first definition, but.
Actually, I have
Just the
one.
way you-
Okay.
Yes, Mr. Chair.
And it's something for the committee to consider, because I was looking at, special prosecutor. We require that person to be admitted to the highest court of their residence. Do we want them to be a member of the Cherokee Nation Bar Association?
I think that's not a bad idea, since if they were going to appear in our courts, they'd have to be. So, I think this is a good place to make a note that we're considering adding that language. Okay. Councilman Keenan?
Thank you, Mr. Chair. B, impeachment means the prosecution through the special prosecutor of an elected official under the Constitution for willful neglect of duty, corruption in office, drunkenness, incompetency, or any conviction involving moral turpitude committed while in office. C, articles of...
Excuse me.
Councilman Thornton?
Why would they leave the felony out of here?
You're right.
If they're gonna put those in, and also the misdemeanor involving moral.
Right.
Why would they leave those out?
Again, this is language that was from the original Impeachment Act, and we didn't have those words under the '76 Constitution. Well, we have them now.
Do they need to be added?
They do. I would recommend that we follow as closely as possible the same constitutional reasons for impeachment in your definition as there is in the '99 Constitution.
And Councilman Keenan, I suspect that was your intent, because you've cleaned it up everywhere else, just this
Yeah.
section. So
Yes.
we want to make sure this definition is consistent with what the Constitution says.
Exactly.
Okay, we will make a note of that for cleanup. All right. Councilman Floyd.
And dropping back up to A, where we're thinking about putting in as a member of Cherokee Nation Bar, I would like to add consideration of language or meet the qualifications to be a member. Because we're really limiting ourselves if we say they have to be, I think there's only about 100 members of the Cherokee Nation Bar. And a lot of those folks are employed at Cherokee Nation in some capacity.
We could, Councilwoman, require that they become a member of the bar within
So
some
many
reasonable
days.
period of time
I think that would be-
after their appointment. Yes, Councilman Thornton?
Why not require that they're a Cherokee by law? And that way you could get people that weren't members of the bar, and you could get Cherokees outside that are lawyers within their own right.
I just didn't want to limit the
I see
pool
what
to
you're saying.
such a point that we
Mhm.
had very few eligible people, because I know that bar is quite limited right now.
There's several Cherokees that aren't on that bar.
But my first thought on that is it's not a bad idea, although the pool of people we might want to be truly independent might be someone that doesn't have ties to the nation that's an attorney. And if you start looking at that pool, and if you say we're just going to look at the Cherokees that don't have some dog in the fight, and attenuated as it might be, maybe the pool gets really small. I mean, I would hope we would appoint a Cherokee. And I'm not saying it's a bad idea, but the first thought I had is we don't want to make sure to not restrict this pool too much. But I think we ought to add this as something for further consideration, is the citizenship requirement, and then the Cherokee Nation Bar Association requirement. And I think for Councilwoman Gloria Jordan, if we just said that they had to become a member within a reasonable period of time, that's pretty easy to do. If you're a member of a bar in a state and you take an oath and pay the fee, you're in. So I think those two things should be something we come back to. Councilman Lane.
And to become a member of the bar, they just simply have to be, have standing in this state and make applications.
Yeah, if you, then I think that's.
Actually, they have to be approved by the Supreme Court.
Have to be approved by the Supreme Court, but it's pretty pro forma. I mean, you get sworn in and meet the qualifications, but I do think it's important that they be a member. I hadn't thought of that.
Question.
Councilman Keenan, yes.
Once they are ready to go to the court, and then the reasonable amount of time, is that they can go ahead and still do the proceedings and at the same time put in an application to be a member? Is that?
I think that's the
Concur?
way, that's what I thought, because, if you wanted to try a case in Cherokee courts right now, you can get permission from the court to be approved. And I think probably one of the stipulations is that you be in the process of getting approved, but maybe Todd could speak.
That is correct. What normally, and I hope I pronounced this correctly, is that if I go to a foreign jurisdiction, I go to Arkansas, I file an application pro hoc vici, which means for this case only, to prosecute that case in Arkansas courts. That type of there is that procedure available under the Cherokee court rules, and that if I don't have time to become a full-fledged member of the bar first, what I do is I do my application to the bar. I file my application pro hoc vici. I don't know if our court requires this, but we would have in some jurisdictions require a sponsoring attorney, that getting an attorney that's already been licensed in that to vouch for you. But I do know that the courts do have the capability, because I've seen it, do a pro hoc vici application in our courts. And Mr. Hoskins is right, it's relatively pro forma. As long as you are a licensed attorney in a competent jurisdiction and have a good record, we're not going to turn you down.
Thank you, Todd.
Councilman Wood.
I've practiced in most of the surrounding states, and as long as I have an attorney in the room that is admitted to the bar there, they give you permission to practice on a case-by-case basis. So usually if I'm going to another state, my client's got the wherewithal to employ someone to sit there.
Councilman Keenan.
Would that help us as far as limiting our pool, and if we could have something similar to that, or we do already have something similar in our courts?
Well, you would have,
Go ahead, Councilman.
when I was over in the court system, I just gave them permission on a case-by-case basis and said, get your paperwork in. The paperwork at that time, of course, that's been years ago. I was over there for almost 8 years. And they would submit their paperwork, and sometimes it took anywhere from 45 to 60 days because the Supreme Court, and then it was called the tribunal, didn't meet on a regular basis. And when they met, they approved everyone. So you let them practice on a case-by-case basis. And that gave whoever the presiding judge was the ability, if they had some compliance problems, to have them removed from the courtroom. And on occasion, you would have that, where they felt that since they were not a member, they didn't have to abide by the rules. And so you would just simply revoke their privilege during that time and move them out of the courtroom. I think I did that once or twice. So.
And Councilman Keenan.
Thank you, Mr. Chair. Let's see, I believe we're on C, I believe. Articles of impeachment mean the articles of impeachment are the written accusations of one or more of the grounds for impeachment prepared and sworn to by the special prosecutor after his/her investigation and determination that probable cause exists and that an impeachable offense has occurred.
Councilman Wood.
From what I could read into this, when you say a special prosecutor, is this special prosecutor, is he going out and investigate this situation? Or is there going to be money for him to have an investigator that goes out and investigates the situation? I don't know of lawyers that actually go out and investigate a situation that's going on. They usually have someone that will investigate for them. So are we going to include an investigator in this process, or we're not? You know, you're saying you're going to here the way I read it, but I don't know if you're actually going to include one in here.
Councilman King?
I think I have to defer to Todd on that one.
We can add in here, and let me see, that, I'm looking for the right place to put it, that the special prosecutor, shall have assistant staff investigators necessary to conduct his or her business. I think it's obviously this is not a funding piece of work, piece of legislation. You know, you do that in your annual budgets, but it wouldn't be a bad idea to put in there that that the special prosecutor has the authority to. And I'm trying to think of the appropriate language off the top of my head, but the authority to appoint and hire such assistants to carry out the functions of his office, something to that effect. But again, that will cut back to funding, and it's probably something you won't necessarily have in each year of your fiscal year line items, but when the situation arises, there's going to need to be probably a special appropriation for the prosecutor to do his or her work.
Another thing that kind of bothers me on this is to even bring this forward from a counselor or from a council, or someone's going to have to go out and investigate that. Whatever, whatever that you bring forward to impeach, for impeachment. In other words, to start the process, either I'm going to have to go investigate it, or someone within the nation's going to have to investigate it. And I don't know who you would go to. Would you go to the Attorney General? Would you go to the Marshal Service? Where would you go?
Well, I'd like to speak to that, Councilman. What we should remember is that the impeachment statute isn't the only means by which an official can be investigated. I mean, if we think the chief is engaging in some violation, we could go through the maybe more routine procedure of contacting the Attorney General, contacting the Marshal Service. This is sort of a special situation. So I don't think the silence of this act on our ability to do that means we can't do it. I think we always could do it. The second thing I'll say is I appreciate what you're saying about the process has to be initiated somewhere. And when we get to it, I have some language that appears in the red line that says you've got to file allegations of impeachment.
Okay.
So suppose a council member wants to impeach another council member. And we'll get there, but under my proposal, you would have to write out an allegation, file it with the Secretary of State. Now, it would be, if it needed some investigating to get to that point, it seems to me that the council member needs to investigate it or have an appropriate law enforcement agency or other office investigate it. But at some point, it will be incumbent upon the accuser to write down the allegation. That's my feeling on it, to initiate this process before we even get to the special prosecutor.
Well, that's what another thing that I'd like to talk about is when you initiate it, do you bring it before the council and let the council initiate it?
I think that's a discussion we should have.
Yeah.
My proposal is that a council member brings a written allegation to the Speaker of the Council, then that is then assigned to a committee or subcommittee to hear that allegation. And if there's sufficient cause to appoint a special prosecutor, that committee will say, appoint a special prosecutor. And then there's a question about what the threshold should be.
And you brought this up on the red line.
I have.
All right. Thank you.
Councilman Floyd.
Is it appropriate at this time to maybe stop on C and ask, are we asking for a recess till the next meeting? A continuation, or are we just going to,
I think we should,
we're running over now.
yeah,
into
we should,
hell.
I should probably entertain a motion to adjourn to next month.
Second, I would like to ask one thing though, that we give some direction to Todd to look at the definition, which I already see, we have one written here of willful neglect, but corruption in office, habitual drunkard, incompetency, and moral turpitude.
Thank
And that
you.
would go there under definitions for next time.
Yeah, any terms that you would want to have a written out definition of, please contact me. Also, I will search the constitutional record as to those other officers.
And
The other officers,
Yeah.
like secretary.
And before we adjourn, we have Councilwoman-elect here with us today, and we appreciate that. Would you stand up and make yourself known?
Frankie Hart.
Frankie Hart. All right, we have a motion to adjourn. You have a second?
Yes.
All right, all those in favor?
Aye.
Opposed?
To what?